My name is Elliott Stapleton, and I am an attorney in Cincinnati. So what I do for clients is I help them protect what they earn, avoid unnecessary expense, and plan for success. What I'm going to cover today relates to specifically what happens if you have been appointed as an executor for an estate or as a trustee for a trust. I'm going to go over the process that you would go through in transferring assets from one generation to the next. So first, let's start with a will. This is probably the most common device that people are familiar with when they think about estate planning. The way a will actually works is if you use it to distribute assets, those assets go into probate court. If the decedent has minor children and no other parent survives, the court would need to appoint a guardian. So a guardian is typically nominated in the will, meaning there would be a person named, and there might be successors named after. The guardian takes over parental control for any minor children. So if a child is 14 years or older, that child actually has input on who is named as the guardian. But regardless of who the 14-year-old child suggests or who is named in the will, ultimately, the probate court makes an evaluation of that person to make sure that they are suitable for the child. On the distribution side for assets, it takes between 6 and 12 months to actually distribute assets from probate, primarily because creditors actually have 6 months from your date of death to make a claim. So you really can't open and close probate within 6 months because that creditor period would have to expire. The cost for administration generally ranges from about 3 to 5% on average of the assets that are actually transferring through probate court. This is somewhat costly and takes a while, and you'll see in just a moment why many clients elect not to distribute assets through probate using a will, but rather use another method. Your control on the distribution of assets is somewhat limited, meaning if you just have a minor child named, when they reach age 18, they would receive assets outright. 18 is not the pinnacle point of most people's maturity level, so this, again, is not an ideal way of distributing assets, but it is one way. And if you happen to have any creditors who are present at the time of the decedent's death, those creditors are going to stand in line and wait to be paid from the probate proceeding. And then all of the information related to probate is actually a public record. So anyone can go online and look up a probate matter to see what assets are being transferred and what liabilities there might be. So this is how probate using a will works. The assets get from point A to point B, but as you can see, it's quite a process. Going through it step by step, prior to actually opening probate, you would have to collect a lot of information, meaning records, death certificates, copies of documents. Typically, you would contact the law firm as soon as possible where the estate plan was prepared, because they will usually have originals and other helpful information for administration. After all of the necessary documents are collected, you can then open probate. This does require sending notice to various parties and has some issues that come up from time to time with parties who may not waive notice, and in some cases you may have to appear in court depending on the circumstances. After you are appointed, the next step is to collect assets and debt information related to the decedent. This typically involves communicating with third parties, reviewing records, and working with the attorney to gather all of the necessary information and then go through a comprehensive checklist to make sure every asset and liability is accounted for in the process. Once you've collected all of the asset information, you then create an inventory. So a list of all of the assets that have been accounted for in your review and put that together and present it to the court. And then anyone who wants to dispute it is allowed to submit or contest the inventory. That doesn't typically happen, but it does from time to time. And then there is a final account and distribution of the assets. This whole process takes between 6 and 12 months. I mentioned before, creditors actually have 6 months from a person's date of death to make a claim. So you're really locked into at least 6 months in most cases. And if there are considerable assets, it takes a lot longer to administer. If there is a minor child involved, you have to go through this process, and then effectively there's another probate process involved where the guardianship would be in place and would receive the assets from the probate estate and then make disbursements to the minor child. But as I mentioned before, there are actually other ways to distribute assets other than using just a will. One of those is to use a trust. And the way a trust works is during life, you place assets into a trust, or you make assets transfer on death to a trust. By doing that, all of those assets avoid the probate process entirely. So it makes it a bit easier to actually distribute and administer those assets. The time for administration might just be a matter of weeks, at most 6 months, rather than 6+ months for probate administration. The cost for administration is a lot less. In some cases, there may be no cost involved. At most, maybe 1% compared to 3 to 5% going to probate. And the control a person can have on the disbursement of assets is really unlimited, meaning you could distribute for, let's say, a child's health, education, maintenance, and support. That's what HEMS stands for. Think of it as the essentials in life. So you could say, in the trust, distribute for the essentials in life, and then maybe when the child reaches age 25, you distribute half of the remaining assets, and then the balance at age 30. Those can actually be any age or any increment the person likes. And there are other options. It could be tied to the distribution when a person graduates from college. It could be tied to a person's earnings or savings at a certain point in life. There are many different options that a person might have within their trust. Also, some clients embed creditor protection for their children or beneficiaries within the trust. What this means is if a beneficiary is ever sued, files bankruptcy, or gets divorced, the assets within the trust could remain protected. This isn't in every trust, but many trusts do contain creditor protection. And then there may be contingency plans within a trust as well. So one could be if a person is deceased, how does that deceased beneficiary's assets, where do they go if they are deceased? It could be to their children or to a charity or third party. Also, if a named beneficiary happens to be disabled, meaning they, perhaps they were in a car accident or developed a medical condition later in life, the trust could say, if that person's on government assistance, don't distribute assets to them directly because they would then lose that government assistance. Instead, you could say within the trust, distribute to supplement their needs and pay for the things the government doesn't otherwise pay for. And then if the trustee happens to be administering a trust and find certain creditors, some of them can be avoided, specifically unsecured creditors. So that would be credit cards, medical debt, student loans, business debt. Of course, it's important to consult with counsel on all of these items, especially here, when determining what creditors can be avoided and what creditors need to be paid. And then also, all of this information is private because there's no court proceeding related to the distribution of assets. So even though there would still need to be a guardianship for a minor child, all of the other assets could be distributed based on the terms within the trust. There are other ways to avoid probate. Many people use these for their life insurance, retirement accounts, transfer on death designations, and you can distribute without probate using those items. And it may be that a beneficiary is named directly as a beneficiary. And if you are the person administering an estate, if it goes to a beneficiary directly, there's really no work for you to do. In other cases, and in most cases, those beneficiary designations actually list the trust, and for good reason. They list the trust to make sure the assets on that side, life insurance, retirement accounts, other things, get distributed to the right person at the right time. And I mentioned before, control that people who create a trust can have, such as distributing for essentials and delaying the final distribution age, creditor protection, and contingency plans. Well, it may be that you find a beneficiary form actually lists the trust as the beneficiary. So let's talk about trust administration and how that works. So the first step is, again, to collect information. You get a copy of the trust. Here again, primarily this would be an interaction with the attorney who created the estate plan. And you could review a copy of the trust with that attorney. Ultimately, if you are the first person named as trustee and decide to serve, you would need to provide a copy of the trust within 60 days to any beneficiary named within the trust. And this, again, is something that the attorney would discuss with you at the time of appointment. Similar to probate, you collect asset and debt information. You create a trust account, fill out beneficiary forms to process the assets, pay any taxes or expenses, the final income tax due for any decedent, which applies, even if there's a probate estate and no trust, which would still apply. But then there might be a final trust income tax return related to any income generated by the trust before distribution. And it's good to work with a qualified CPA whenever administering an estate. That way, the taxes are accurately filed, because there can be some overlap between the trust's income taxes, the estate's income taxes, and the individuals. And it's good to work with a professional on all of those filings. And then there's also a final account here where you prepare a comprehensive list of all transactions in the estate and then distribute the assets. And the key here, as with the probate process, is to keep good records. So if you have to advance any costs, do so in such a way where you maintain a receipt and you maintain the invoice. So you confirm why the payment needed to be made and how you made that payment if you had to advance any costs. So I hope this information is helpful. When the day comes, if you have to serve as the executor or trustee, feel free to review this and feel free to reach out to me. Thank you.